It is time for the legal landscape here, home run on the edge. Now, employees are entitled to paid time off in many different instances. So there are common instances which include sick leave or vacation leave. But how are these leave entitlements to be provided? Are employees entitled to leave in their first year of employment? Do they have to qualify, and can leave entitlement be lost or taken away? Also, there are other instances where employees are entitled to receive paid time off from work that are less common than vacation leave or sick leave. So to discuss this topic in further detail, Associate at DunnCox, Ms. Paulette, my tongue today. Associate at DunnCox, Ms. Paulette Neil is our guest today. You're going to charge me for that slip up?
No, I won't.
Thank you. Thank you, Ms. Neil. Welcome today. And I guess at a time like this, it is important for everyone to understand what their rights are. So we're looking at leave entitlement. In what circumstances may an employee be entitled to paid time off from work?
Well, there are various circumstances in which an employee may be entitled to paid time off from work, and I'll just briefly mention 3 instances. So, firstly, if an employee suffers personal injury from an accident arising during the course of his employment, that employee may be entitled to paid time off from work for recovery, even if it is for an extended period. Secondly, the Holidays with Pay Order 1973 makes provision for a worker's entitlement to paid sick leave and vacation leave once they meet the qualifying criteria. So under that order, any worker other than a casual worker who has worked no less than 220 days in any qualifying year, and that is a period of 12 months, is entitled to a statutory minimum of 2 weeks vacation leave with pay if that worker has worked or provided less than 10 years of service to his employer. And that 2 weeks increases to 3 weeks per annum after 10 years of employment. There is also provision under the order for paid sick leave if the worker has worked no less than 110 days in the qualifying year. And thirdly, female workers are also entitled to paid time off from work in the form of maternity leave if they meet the requirements under the Maternity Leave Act.
And can I just ask you, for paternity leave, is the paternity leave then still voluntary for those persons? Because we said maternity, but I know we've heard some talk of paternity and maternity. So we'd advise the fathers, if that's important to them, to just speak with their place of employ to find out what their concerns are with that, right?
Right. There is no provision under labor laws for paternity leave. However, we have seen in recent times where, different companies have incorporated policies which provide for paternity leave.
All right. So you mentioned that a worker who meets certain requirements is entitled to vacation leave with pay. When would such a worker be entitled to take the vacation leave? We have to re-emphasize this point.
Right. So vacation leave earned by an employee in any qualifying year is to be granted by his employer in the next succeeding year. So if, for example, an employee earns 2 weeks vacation leave in the first 12 months of his employment, that employee is entitled to take those 2 weeks vacation leave in the subsequent 12 months of his employment. The vacation leave taken, it must be at a time convenient to both the employee and the employer, and it may be granted in 2 periods. However, Deon, it's important to note that there's nothing preventing an employer from granting an employee vacation leave within the first 12 months of his employment, because once that employee has worked more than 110 days but less than 220 days in any qualifying year, that employee has earned 1 vacation day for every 22 days work.
All right, you're listening to Associate at DunnCox, Ms. Paulette Neil. I love how she's speaking. She's making everything so clear for us where leave is concerned. Let me ask you, can an employee accumulate their vacation leave for 2 years or more?
Well, if it is provided for in the terms of your employment, whether in your employment contract or by a policy within your organization, vacation leave due to be taken in a particular year can be brought forward to the next year, but not for more than 3 consecutive years. So in the absence of such express provision within the terms of your employment or, with an agreement of your employer, an employee who fails to take his vacation leave in any year it becomes due will automatically forfeit his rights to his vacation due that year. So basically, you either take it or you lose it.
Take it or you lose it. Can I just ask you, and I think Lorna in Portmore wanted us to just ask if what we're talking about, if the rights also include persons who do days work, if they have similar rights.
Well, it doesn't provide for casual workers. Days workers are generally casual workers, but what I'm speaking about is any worker other than a casual worker.
All right. So, if a worker has utilized all his sick leave in any given year, and subsequently gets COVID-19 through contact with another infected employee or otherwise, would that worker be entitled to paid sick leave?
Well, strictly speaking, the holiday pay order, a worker other than a casual worker who has met relevant statutory requirements is only entitled to 2 weeks paid sick leave per year. And, as expected, our legislation did not make any provision for any exceptions due to COVID-19 or otherwise. Mm-hmm. So in an event where an employee has utilized all his sick leave available for any given year and later contracts COVID-19, whether it is suspected through, another infected employee or otherwise, there is no entitlement to paid sick leave during that period of illness, in this circumstance. Mm-hmm. However, we know that under the disaster risk management order, if you contract COVID-19, you're entitled to quarantine. So that employee may be granted a leave of absence without pay for that period of illness in such a circumstance. But beyond just to give a practical possible solution or recommendation or suggestion, if, for example, an employee has exhausted all his sick leave for a particular year and later contracts COVID-19, if that employee is, luckily asymptomatic and the nature of his job would enable that person to work remotely from home, then that employee could continue to work and there would be no need for time off without pay. Mm. So that is something that can be discussed with your employer and considered.
Mm-hmm. Let me move on and ask you, is there an entitlement to leave with pay in the event of the death of an immediate relative of an employee?
We have seen where some companies have chosen to grant what is known as compassionate or bereavement leave in those instances. However, there is no provision in our labor laws that requires companies to grant such a leave. It is entirely a matter for the discretion of the employer, if the employer wishes to formulate such a policy to facilitate an employee taking time off from work, whether paid or unpaid, to attend to emergencies involving the death of an immediate family member or serious illness. So if in the absence of such policy, an employee cannot demand time off from work, whether paid or unpaid, or, in such an instance.
Interesting indeed. All right, last one I'm going to ask you for this before we go. How does an employee qualify for paid maternity leave and for how long?
Okay, so maternity leave only applies to female workers. And in order for a female worker to qualify, she must first be at least 18 years of age or older. She must be continuously employed by her employer for no less than 52 weeks prior to the date her maternity leave is to begin. She must have informed her employer in advance or as soon as reasonably practicable of the expected week of birth. She must also produce a medical certificate if her employer so requires. And she must not have been granted maternity leave with pay on 3 previous occasions. So if a female worker qualifies for maternity leave, then she should be given 12-week leave, known as the maternity leave, but she's only entitled to 8 weeks pay she's only entitled to pay for 8 of the 12 weeks.
Oh, so if anyone wants to do anything outside of that, they're fine to do it, but that's what you're entitled to.
Right. So you'll notice there's 1 month in which you're not entitled to pay.
Mm-hmm. I really have to thank you so much for sharing with us. Before we go, what's your hashtag Did You Know tidbit for today?
Well, Deon, unfortunately, I don't have a Did You Know tidbit, but what I will say to close is this area of law can be a little tricky. And if you're an employer and you're uncertain as to whether an employee is entitled to time off with pay or how much time off with pay, my suggestion is that you seek guidance from the Ministry of Labor and Social Security or speak with an attorney who practices employment law.
So that's your hashtag Did You Know tidbit for today. Where to go for the information that we need to. Oh, there's always a lot that we can do. So we're looking forward to next week, Wednesday, with another legal landscape. And today we have associate at DunnCox, Ms. Paulette Neil, as our guest, helping us today. We'd like to thank those persons who sent in their questions as well, too. Keep on listening to The Edge 105.1, 105.3, and maybe it will be you, Ms. Paulette Neil. Thank you so much for joining us this week, associate at DunnCox. Look forward to speaking to you again.
Thanks for having me on.
You're welcome. Always a pleasure. Bye and stay safe as well, too. I should have said that before. I should have found out how wet, But no, I mean, I hope we gave you some interesting information there. Did you hear anything that you didn't know that had you thinking? And I didn't know that there was only a certain number of pregnancies that they have to.
I did not know that either.
I did not know.
I didn't know that.
Did not know. You see, there's always something to latch onto and to get through with information here on the Edge 105.1, 105.3 FM. So, just before I go into playing some more music, anything you want to say with that?
No. It was some good information.
Oh,
and
yes.
Yeah, because I'm sure a lot of it people really didn't know or had questions about or were iffy about, and those were clarified. So that was good.
So some of the boss I'm aware quarrel for we realize that, oops, we better just hope the boss not listening. Should I have said that, boss? Employer, 15 minutes away from 6 o'clock on The Edge.